married, they get homesick 2 years later, they come back to Virginia. Very hard to hide the fact that they're an interracial couple, and they get busted. They get sentenced to prison and a hefty fine. And they take it through the appellate process up to the Supreme Court. And once again, the court says, according to the 4th, 19th, and 14th Amendment, you have a zone of privacy where the government can't put their nose in your personal marital business. They cannot tell you who you can't marry. That's your choice. That's your libertarian freedom. As long as you don't interfere with anyone else's freedom, you ought to be allowed to do whatever you want to do. Everybody follow that? So the two concepts here is the zone of privacy that we're establishing in federal law, Supreme Court law. Then we get to 1973. This is the beginning of the abortion module. This is Roe versus Wade. Roe is a pseudonym, a false name for a woman who wished to have an abortion, defined as the intentional termination of a pregnancy by inducing the loss of the fetus. Texas statutes, it says forbade, which is forbid. That's language of the court. Forbade abortion except to save the life of the mother. She took it to the district court, and the 3-judge district court said she had reason to sue. Texas criminal abortion laws were void or unconstitutional on their face. The right to have children was protected by the right to privacy. So what we have now is we take the concept right to privacy, which is applied to marital affairs, and we now move it to what I call eminent domain. Everyone has the right to protect their body, both what happens to it and what occurs inside of it. That's why we can't castrate rapists. I can't give you drugs that you haven't consented to that might have effects. When you go through these trials, these drug trials, you have to consent to all of it. They tell you what it might do to your body. You have control over everything that happens from the outside and inside your body. There's a zone of privacy that belongs to you. It's just the enhancement of libertarian philosophy. You should not be able to bang my nose because you don't like what I'm doing. Everybody get that? So we're building this upon the zone to privacy, which was established in Griswold and then established in Loving. We are expanding the definition of it. It is now personal property. This is your property. Look, we went over this, people. John Locke in 1698 said you have self-ownership. You no longer belong to the kin. Your body belongs to you. And therefore, through self-interest, you can do whatever you want to with your body as you deem fit. Now, we have limitations to that, obviously, as the law progresses, but technically, in the broadest philosophical sense, you can do whatever you want to your body as long as you don't interfere with anybody else's freedom. Later on, when we get to euthanasia, you'll find out it's not against the law to commit suicide. People get that wrong all the time. There's no law against it. It's your body. It was prohibited by Locke when he wrote his second treatise on government, but there's no law against it. Everybody with me? Okay, so a woman's right, zone of privacy. She can do anything to and inside her body. Now we go back to moral standing again. She has a critter in there. What kind of moral standing does the woman have? Full moral standing. The court decided in Roe that you were a person if you were newborn, and if you're not newborn, then you're less than a person according to the law, and therefore you lack full moral standing. You can do things to entities that have less than full moral standing that you can't do to entities that have full moral standing. This is the foundation of a woman's right to terminate her pregnancy. It's her pregnancy, it's her body. And I know we have the religious conflicts. It's fine to have those. Life begins at conception. Some say it's just a ball of cells until it gets to the second week, and it goes from being a zygote to a blast. We go through all of these different ethical discussions that we have. But this is built upon the concept of a zone of privacy, and the court reinforces that in Roe. Implicit in several amendments to the Constitution, the word privacy never appears. Earlier recognized to use contraception, interracial marriage extended to whether or not to have children. The 14th Amendment specifically they used was due process. Now they also included something called viability. Viability means the ability of the fetus to live outside the woman's body. Now, back in these days in '73, about 36 to 38 weeks was the limit of viability, because the last thing that happens when a fetus is developing is the lungs come on board. You don't need them. You're in liquid environment. So everything else is growing. The lungs are there as these little buds, like little fists, and suddenly the chemicals work, the DNA works, and suddenly the lungs are produced. You pop out of the oven, you go from liquid to air, and if you can't breathe, you're dead. But it's the last thing to come on board back in '73. So the court acknowledges if a fetus is close to being born, it has to make a decision, okay? And it's going to come down in favor of the woman for the most part, because it's very tenuous to take a fetus out at that point way back in '73. We did not have the medical advances we have now, and I'll get to that when we get to Webster versus Missouri Health Services. So, number one in Roe, you have to know, there's going to be 5 here, and you have to know them all. A woman's right to terminate her pregnancy is based on his own privacy. Now, a guy named Justice Blackmun is the one who gives the decision. It turns out it's 72, 7 judges for it, 2 against it. Blackmun pointed out that the right to privacy applies to a woman's decision on whether to terminate her pregnancy, but that her right to terminate was not absolute. So, way back on day 1, we had this picture, and we put rules up here, and we said rules equal to law, and we wanted the law to be written in stone. Everybody remember that? And we said this kind of stone then we call ethical absolutism. We don't want the law moving. Red light, green light, no lying, stealing, cheating, raping, and robbing. But we pointed out in a libertarian democratic society that we also have to have a little bit of flexibility. And we call that flexibility ethical relativism. Now, when the court made this decision, they did not know I drew that picture on the board. Blackmun says that the right to privacy applies to a woman's decision on whether to terminate her pregnancy, but her right to terminate is not absolute. If it's not absolute, what is it? What happened then is the court, without intention, left the door to the barn wide open. If they would have said, and her right is absolute, you would have had to find fault with how they decided that law. But they didn't do that. They said it's her right, but her right is not absolute. If it's not absolute, it's relative. There must be some wiggle room in this, and it turns out the wiggle room is going to be money. And I'll point that out as we go through the rest of the lecture. I'll point it out to you. Good. Jada.
So, quick question. I watched a show a long time ago, based on a true story. A young girl was raped by an older man, and she ended up getting pregnant through the rape. And she was trying to protect the child because the rapist wanted to see his child and have rights to his child. And she did this whole, well, grandfather traveled across the whole country to avoid this rapist seeing his child. And they went to court, and he said, well, I have a right to my child, but the statute of limitations of rape had expired at that time. So in that case, I mean, would this apply? Same? Like if she didn't want to, if the woman got pregnant as a product of rape and wanted to terminate the child, would the rapist then have the rights to the child?
No. And look, here's the odd thing about the law. It's a great question, because we say the law is black and white, and the law is not black and white. A woman can terminate a pregnancy. If you kill a woman in a car accident and is pregnant, you can be charged with 2 murders. A female at 14 years old can have an abortion, but you can't have aspirin. And you can't have a tetanus shot. So the law defines things, but it's not consistent across the board. So in this case, it's a woman's right. Once Roe is legitimized by the Supreme Court. That's why I told you, I'll repeat this, my first wife had the 3rd therapeutic abortion ever granted in the state of North Carolina. That means for her mental health, they allowed her to abort the fetus. The male has nothing to say about it. I mean, I went to talk to the doctors, and they said, I don't even want to hear what you have to say, because the law says it doesn't matter what you say. But 23 and 23 male-female chromosomes, go figure. So I'd like to say it's black and white and cut and dry. It isn't. You can take those things to court. Maybe a court's going to be a little more sensitive to your point of view. There's a guy in California right now beat a lady's head to death with 57 times with a ball-peen hammer, and they won't give him the needle because it's cruel and unusual punishment. And there's a judge who said, you're right, right. So he's sitting on death row right now, life without parole. Go figure. Does that help? I mean, it's not clear. It's as clear as mud. It's up to the court. What the decision does is this decision points out certain parameters that they say they're going to live with. But when we get to 2007, I'm going to show you that they moved the goalpost a little bit. What happened in the, was it a movie or a real case?
It was a true.
And did they give the rights to the rapist?
Well,
that would blow my mind if they did that.
Saying that it was consensual, but because he was admitting to that the child was his, they took it as his admit to the rape.
To the rape.
The girl was only 16, so she wasn't even a legal adult. So he was trying to argue, well, she's only 16, she's not an adult by the law, I should have full rights to my child. So that story ended up where, by him admitting that this was my child, he admitted to the rape, therefore has no right to it.
No rights to the child, yeah, that makes sense then. Okay. Yeah, but look, the law is never going to be black and white. There's always going to be room to wiggle in it. Those of you who are medical people, you're protected by the Good Samaritan law. You try and save someone's life and they bleed out, you may get taken to court. The law's on your side, but that doesn't mean it's always going to justify what you did. Say again, dear? Well, then you can be sued forever. We have the same exact procedures and outcomes, and one's protected and one isn't. Go figure that out too. And if we both save the person, but maybe there's complications, the one who's not certified, they could always be blamed for the complications, even though medicine may say there's no way that happened. They can still take you to court, and who knows what the court's going to decide. You know, lady has a hot cup of coffee, puts it between her legs, an older lady, you know, spills on her genitals. She needs 3 surgeries. She was wounded, you know. McDonald's was going to pay $38,000 for the surgeries, and she wanted more, and they gave her $2.6 million or $2.8. They went back and reviewed it, and they gave her $600 and some odd thousand. So your genitals are worth $500,000. I guess your whole body. Hey.
She asked for the money to pay for the surgery, and they told her to take her off, so she sued them. She had to. She didn't have the money to pay for it.
What they did too, the initial justification for suit was that the coffee was way above what would be considered normal hot. And McDonald's justified in saying most people who come to the drive-thru want it extra hot because they don't intend to drink it then. They're taking it to the office, it cools down over a few minutes of driving time, and then they still have a hot cup of coffee. I mean, it goes back and forth. You can argue it all day long. The court decided one thing, the jury decided another. The court said no, too much money. She ended up getting a lot of money. She was in pain. An elderly lady had 3 surgeries. Turns out she had like cotton sweatpants, so it just soaked in there, really burnt her. I mean, 3 surgeries. She had, I think, 3rd-degree burns on her genital area. It was painful. They gave her pain, suffering, and go figure. Okay, so back to Roe. We're cool. Okay, so it's a woman's right to terminate, but that right is not absolute. That's what leaves the door open. So that's the first one. Number 2, a fetus is not included within the legal definition of a person. Now, I have to make another observation to you. In philosophy, when we talked about moral status, we were concerned about whether a fetus was a person or not. Legally, in philosophy, and I'm not going to go into detail with you, it's called ontology. This is the study of being. What kind of things